right, I think we can go ahead and get started and let people continue to come in. We'll just sort of cover our introductions here. My name is Marjorie Greek, and I am the owner of Pro Fiduciary Services and the co-chair of Boulder County Senior Law Day. So I'd like to welcome you all to the 2021 Boulder County Senior Law Day, which has been actually a series of webinars this year. It was our second year in this virtual format. And hopefully next year we'll get to see each other in person again. But one of the good things about having it in a virtual format is that today's session is being recorded. And the video will be available hopefully within the next couple of weeks on the Boulder County Senior Law Day website and our YouTube channel. And I will get you that link information in the chat box a little bit later. So you've entered this presentation in mute mode, and you'll please stay that way unless the speaker invites you to unmute yourself. We will be taking questions, but those, if you could write them either in the Q&A or the chat box, that is located at the bottom of your screen in the menu bar. If you don't see it, just kind of activate your screen and it should pop up, and then you can just type your questions into those boxes. We will be taking questions at the end of the session, but please feel free to write them as they come up for you so that we can take a look at them as we're going along. So upcoming webinars, unfortunately, there aren't any more. This is the very final webinar of our series. We've had a number of really excellent presentations. Again, all of those will be recorded and shown on our YouTube channel, so be sure to check those out. We'll send an email around to everyone when they're up and posted. Again, this bocoseniorlawday.org or bouldercountyseniorlawday.org, which is our website, will be posted in the chat box, so you can see that in just a short while. The Boulder County Bar Association, one of our platinum level sponsors, has a virtual free legal clinic that they host year round. So if you want to participate in that, you can give them a call or sign up at their website, and you'll be able to have a brief consult with an attorney on a variety of issues. So you can call them at 303-440-4758 or apply at boulder-bar.org. And this information too will be posted in the chat box for you. Senior Law Day handbooks, which are an amazing resource, are available online these days. You can go to that seniorlawhandbook.org and check it out. Or if you want to hold your phone up on the camera with this QR code, it will give you a link, and you just tap on that and it'll take you right to the Senior Law Day handbook. Again, I will put this in the chat for you. And we also really want to thank our sponsors. Without these sponsors, we would not be able to bring these webinars to you. So our platinum sponsors this year, the Boulder County Bar Association, Pro Fiduciary Services, and Frazier. Jorgensen, Brownell, and Pepin were a gold sponsor this year. Silver sponsors were Hofgaard and Associates and BOK Financial. And the bronze sponsors were Kingsbury, Johnson, and Love, and the Friends of the Longmont Senior Services. I also want to thank the rest of the planning committee who've made this year's Seniors Law Day possible. Brett Landis, who is my co-chair, Pete Rogers, Erica Corson, Deidre Braverman, Maya Labrie, Allison Oates, and Susan Spalding have all done a bang-up job of pulling all of this together for you. So now I'd like to introduce our presenter today. John Estes is an attorney at the Kapsak Law Firm in Longmont, Colorado, where his practice focuses on estate planning, estate administration, and elder law, including Medicaid planning and planning for long-term care needs. Prior to joining the Kapsak Law Firm, John worked for the Colorado State Medicaid Department, drafting long-term care regulations. John is a proud member of Niwot Rotary, and in his free time, he enjoys training for and racing triathlons. John, we're really looking forward to your presentation today. Thank you.
Wonderful. Thank you for the introduction, Margie. And I will go ahead and share my screen so that everyone can follow along with me. And today's, I'm going to be talking about Medicaid and specifically long-term care Medicaid. So we'll start with some of the basics and then move into the kind of high-level information that anyone who's looking at long-term care Medicaid needs to know, including some of the common pitfalls or areas that people tend to run into problems and how we can help address those and be proactive about getting to that place when a family member or loved one needs it. All right, so the first high level what is Medicaid is that it is a combined program between the federal government and the state government. So the federal government sets certain regulations that all states that have Medicaid programs must follow, but then within that, the state has discretion to craft its Medicaid program in the way that it sees fit to serve its own population. It is a safety net program, which we'll talk about because there are limits and exclusions to who is eligible and what steps you need to take to become eligible for this. It's not available for everyone. And each state's Medicaid program is different. So that goes with being the joint federal and state program. There are certain things that will be common among Medicaid programs in every state, but everything that I'm telling you today is going to be specific to Colorado. It may not apply to family members or friends who are looking at long-term care Medicaid in another state. And then another common, or at least one common thing that clients and people talking with me about Medicaid often get confused is the difference between Medicaid and Medicare. At the federal level, they're both run by the same agency, CMS, but they serve different populations and they serve different needs in different ways. So Medicaid is a safety net program. It has restrictions on assets and on income. It's there to catch you if your own means to provide for your long-term care have been exhausted. Medicare is an entitlement. You pay into it your entire working life. And once you hit 65 years old or have a qualifying disability, you're entitled to receive Medicare insurance. They do cover different populations. So Medicaid has two different programs we'll get to in a second. Medicare is supplemental insurance for the elderly or for the disabled. And they cover different needs. And this is, I think, the biggest one. Many people believe that because Medicare is designed for individuals over 65 years old, that it is there for long-term care needs such as nursing facilities or in-home care. And it really is just a supplemental insurance program. Its benefit coverage for long-term care is fairly limited. So if you're looking at long-term care, despite Medicare being a program for the elderly, it is really not designed for that. The benefits that it provides, at least as far as long-term care, are pretty minimal. It does have excellent prescription drug coverage. So it's not to say that it's a bad program for individuals who have those needs, but it doesn't cover nursing facilities. And that's one of the main things that we're looking at with long-term care Medicaid. Okay, so one of the differences that we've kind of talked about is Medicare is federal. It's not differentiated at the state level. It's the same across all states. And the long-term care coverage piece. Medicare has limited long-term care coverage. It can generally only cover about 20 days in a hospital or rehab facility. Medicaid, once you're eligible, will cover all costs of long-term care, rehab stays, nursing facilities, or even in-home care. And Medicaid is a big budget item, and it's a big, important piece of the state's safety net. So Medicaid covers about 1/4 of Coloradans. It's the primary insurance source for about a quarter of the state, and that's between its two programs. So there's MAGI Medicaid, which we're not going to talk about much, but that's your income-based Medicaid that is a primary health insurance source. If you're under a certain income limit, you qualify, you are eligible. You often find out if you're going through the state health exchange, and you can get on that program. Long-term care Medicaid has more restrictions, but covers a lot more care. It still accounts for over $9 billion annually from the Colorado state budget, and the nursing facility expenses are the single largest line item in Colorado's state budget and have been for much of the last decade. And with the increases in cost in long-term care, that number continues to go up in both net terms and as a percentage of what the state government pays. All right, so as I mentioned, Medicaid has two components. We're going to be talking about the long-term care piece, and this is what you would think of for a nursing facility or in-home care services. So it's all services necessary to care for individuals with extensive assistance needs. And that could be activities of daily living, getting up out of bed, cooking for yourself, cleaning, laundry, getting dressed. Anything that you're doing on a daily basis that you need assistance to do, that's what this long-term care program is designed to cover. So that may be someone coming into the home a couple hours a day, or even for most of the day, to help that you have access to food, that you can clean your house, clean your clothes, get you up out of bed, etc. It's primarily associated with elderly individuals or individuals advanced age, but it can be for individuals with disabilities at any age. And it's expensive. The individual costs, as with anything, vary based on the individual, but in certain circumstances, it can be in excess of $10,000 per month to go into a private facility in Boulder County, or to be receiving 24/7 in-home services if that's what's necessary. And so that brings up the question that most people are concerned with when it comes to long-term care, which is, how do we pay for it? Most health insurance plans do not cover long-term care. They cover it as a separate rider. If you are eligible for that and paying for long-term care services is something that is part of your plan, it's worth discussing with a knowledgeable health insurance provider, someone that you trust, about what their company offers and how it's structured, because there are some benefits, especially if asset preservation and being able to leave something as an inheritance is something that's important to you. Another piece of that is flexibility. Private care health insurance can generally pay for you in any facility. Medicaid services are limited to Medicaid specific providers. Private pay is an option, as you can imagine, at $10,000 a month, or even some of the more reasonable $5,000 a month facilities. That's still going to eat away at your lifetime savings fairly quickly. And then public pay government assistance, the primary two programs are Medicare and Medicaid. There are some programs for certain groups through the Social Security Administration as well, military aid and attendance, Veterans Affairs. Those are some programs, but the primary payers, the primary sources for most people are Medicare and Medicaid. All right, so what do you need to be eligible for long-term care Medicaid? And this is going to be the primary thing that most individuals who come to me, or most individuals looking at long-term care Medicaid, need to be aware of, need to at least have in the back of their mind, so that they're not accidentally causing themselves issues with eligibility later on. And generally, there's two requirements that we have control over and two requirements that are outside of our control, or we have limited control. The first is citizenship requirements. So to be eligible for long-term care Medicaid, you must be a US citizen or legal permanent resident. and you must be a resident of the state of Colorado. If you're a resident of another state, you need to be going through Medicaid through that state's requirements. And then you must meet a medical functional needs threshold, which essentially means that you need assistance with at least one activity of daily living. And that is determined by, once you apply, someone comes out, meets with you, or can just look at your medical records to see what the underlying causes are, and see if you're someone who does need assistance with getting through those activities that I mentioned earlier. And there are some additional ones, but those are the primary ones that end up resulting in eligibility through this functional needs threshold test. And then the other two pieces are financial. So this is a safety net program. It is designed to be used once you have exhausted all of your private resources and ability to pay. So there are both resource limitations and income limitations. And these are the primary two pieces that people need to know about when they're applying for Medicaid. They're the pieces that take the longest amount of time in the Medicaid application itself. And they're the pieces where people can accidentally or inadvertently cause eligibility issues if they're not aware and aren't talking to the right people or aren't looking through things proactively. All right, so the citizenship requirements: citizen, legal alien, legal permanent resident, and must be a member of resident of Colorado. Fairly straightforward. Same thing with the functional needs assessment. And for the income is where we get a little bit more in depth and where we can start, planning for this, making sure that we're eligible. So there is an income limit for long-term care Medicaid. This number does change every year. It gets a cost of living adjustment. And in 2021, that limit is $2,382 per month. We've talked about how the cost could be as high as $10,000 per month, and you're only making $2,300, $2,400 a month. There's a gap there. So for instances and individuals who have income in excess of $2,832 per month, but don't make enough to cover the cost of private pay or even Medicaid reimbursement rate nursing facilities, they can use what's called an income trust to basically accept all of the excess income that the individual has, hold it, use it to pay their medical costs, and get them under the income limit for the purpose of Medicaid eligibility. There's also a resource limit that is $2,000 for an individual and $3,000 for a couple. When we're applying for Medicaid, if you are single, you're just looking at your numbers, your income, your resources. If you're applying as a married couple, income is looked at individually. So only the applicant's income is looked at in determining whether they are eligible for Medicaid or not. But resources are considered to be joint. So all of your assets together are looked at in determining whether or not you're eligible for Medicaid. There are spousal protections for what the person who is not applying. So we've got the Medicaid applicant spouse, and we've got what's called the community spouse in the regulations, and that's the individual who is not applying for Medicaid benefits. One important piece with resources is not all of your assets are counted in towards that $2,000. So the primary assets that are exempt are your equity value in your house, and that's up to $603,000 of equity in 2021. You can have one vehicle of any value as long as it's the primary vehicle used for getting around. If it's an investment vehicle, such as an antique, something that's being held for investment purposes, Medicaid can say that's not your primary vehicle. But otherwise, it doesn't matter if it's a $2,000 car or a $30,000 car, the entire value of that vehicle is exempt from being counted as a resource for Medicaid. Life insurance policies are exempt so long as the face value does not exceed $1,500. If the face value is in excess of $1,500, then the cash value of that life insurance policy does count towards that $2,000 limit. Irrevocable burial insurance policies don't count. It doesn't matter what the value of that policy, what it will pay out after you die is, the entire amount is exempt. And personal property, again, if it's not used for investment purposes, so investment artwork or anything like that might be countable, but your furniture, your clothing, your bed, your computer, all of that, none of the value of that counts towards that $2,000. And if you're applying as a married couple, then you get a community spouse resource allowance. So the non-applicant spouse can hold an additional $130,380 in assets that would otherwise be countable for determining Medicaid eligibility, and keep that and still have their spouse get onto Medicaid. One important thing with this is that this is what we often refer to as a snapshot in time. That number has to be under the $130,380 at the time that you are applying for and getting your spouse eligible and onto the Medicaid program. Once your spouse is on Medicaid, the community spouse may start accumulating assets in excess of that $130,000 and start rebuilding their personal wealth. The idea being we want to be able to keep that individual able to live in the community, able to meet their needs, not be impoverished just because their spouse is now on Medicaid receiving assistance. There's also a benefit for a spousal monthly minimum maintenance needs allowance. And this is a supplement to the community spouse's monthly income. And this is primarily applicable in cases where the individual that needs Medicaid is also the partner that was the primary income earner between the two of them. So if it's their pension, their retirement that's providing the majority of the monthly income for the couple, then rather than have that all go into the income trust, some portion of that can go back to the community spouse to make sure that their needs are able to be met without impoverishing them. All right, as we talked, all resources are joint, but income is coordinated separately. And this does provide us for, with couples some opportunities to preserve some assets, make sure that we can protect the community spouse if we get on top of it early enough and get the medically needy spouse, the spouse that needs assistance with daily living, onto Medicaid while preserving some or all of the assets for the spouse that is still a member of the community. With all of this, whenever I'm talking with clients, whenever I'm working on Medicaid planning or just helping people to understand, one of the things that we always keep in mind is the idea that just because you need to get down to these, you're not free to do with whatever you want with your assets. There's a 5-year look back period. So from the date that you apply for Medicaid, the state and county can look back 5 years at all of your transactions to see if you have made any transfers without fair consideration. I often just simplify that to gifts. It's not specific to gifts, but that's primarily what they're looking at. So if you came into my office and said, all right, I've got $200,000 in assets, but I need help now, I need to get onto Medicaid, and I don't want to use this money to pay for my care, and I don't want the state to get this money. What can I do to protect it? Anything we do right now with that $200,000, we have to make sure that we're not doing a transfer without fair consideration. We have to make sure that we're not gifting it away. You can't just give that as an early inheritance to your kids. You legally can, but it's going to result in you being ineligible to receive Medicaid assistance for some period of time. And that's actually a formula that varies region by region within Colorado. And so that's known as the penalty period. All right, so the penalty period, as I said, is a calculation. Let's, to make the numbers easy, I'm going to assume that the value of the gift is $200,000 and the average cost of a facility in your region is $10,000 a month. The way that the period that you're ineligible for Medicaid is determined is based on the value of that gift divided by the average cost of care in your region. So in our example, $200,000 gifted $10,000 a month means we've got a number of 20, and that's going to be 20 months that Medicaid will not pay for your long-term care needs. So during that penalty period time, you need to find some way to have your needs met without any assistance from the state, from Medicaid. And the penalty period starts not at the date of the gift, but at the date you would otherwise be eligible for Medicaid. So it causes a major problem for a number of individuals who inadvertently get into this situation, because now you have already given away all your assets. By definition, you have less than $2,000 when you reach this place. And now you have to meet your long-term care needs with no money for whatever period that penalty period is. So avoiding this penalty period is generally our strategy. There are some circumstances where we may want to intentionally trigger this penalty period, but I strongly advise, if that's what you're looking at, engage with a Medicaid planning attorney, an elder law attorney who knows this, who can guide you through it, who can make sure that you are protected while doing this strategy. And that's beyond the scope of this presentation. So if asset preservation is something that's important to you, there may be some strategies that we can help walk you through, but it's definitely not a do-it-yourself. You want professional help walking you through that process. All right, so some common issues that people make that trigger this penalty period. Some are accidental. Many times it's just not knowing, or knowing that we have to get down to this 2,000, not being aware of the 5-year look back. So a number of times I will have clients come in and say, yeah, I gave my son $100,000, or I gave my son $50,000, and now I need to get onto Medicaid, and that gift was maybe only 2 years ago. Now we've got to either find a way to pay for 10, 12, 13 months of private pay, or we have to get the money back from the son or we have to make it another 3 years to get outside of that 5-year period, so that Medicaid never even looks at that gift. So that's a common one where people are not thinking about Medicaid at all at the time that they're making these gifts to family or friends, or they're only aware of the $2,000 amount and not aware of this penalty period. Oftentimes people will use trusts as the primary means of distributing their assets as part of their estate plan. That is a part of my practice as well, and there are lots of good reasons for using trusts. They do cause issues when we're talking about Medicaid planning as well, so there may be competing interests in what you're trying to do. But Medicaid takes the view that any assets that are in a trust are countable, even if the asset, if it was in your name alone, would be one of those exempt resources that we talked about. So a common issue here is a couple has put together a revocable trust. They have titled their house into the trust because that's what their estate planning attorney advised them to do, because that made sense for everything else that they were trying to accomplish. And now if one of them needs Medicaid, rather than getting that equity value in the house not counting towards Medicaid as a resource, it's entirely counted in that trust. The entire value of that trust is a countable resource. Oftentimes this can be simply undone by transferring the title out of the trust back to the individual, getting it titled into the non-Medicaid spouse's name, different ways that we can work around this. But so that's not always that big an issue. Where it can be an issue is if it's been transferred into an irrevocable trust. Any transfers into an irrevocable trust count as a transfer without fair consideration. So we either need to be outside of that 5-year look back, or we need to have planned for that contingency. A big one that families run into is as mom and dad age, they start needing care in the home. And so maybe son or daughter steps in and starts providing that care. They maybe start out as, yeah, I'm going to do this because I love you. Or maybe it's an understanding between mom and dad and child who's providing care that this is in exchange for your ability to work outside of the house, so we're going to pay you for that. Any payments made to a family member, a friend, who's providing that care are counted as a transfer without consideration, unless there's a contract, and it has to be a fairly well put together contract in place before any payments to that family member are made. Otherwise, the total value of those payments is going to be treated as a transfer without consideration, and you're going to have either a penalty period or you're going to have a fight with Medicaid to prove that this was actually a legitimate contract, that this wasn't a way to try and get assets out of the Medicaid applicant's name prior to getting onto long-term care Medicaid. So if you are looking at that, my recommendation again is to work with a professional in drafting that contract. It may seem silly between family members, but that contract does need to be sound. It needs to specify what the services are going to be, what the hourly expectations per week are going to be, what the rate of pay is going to be. Is the rate of pay commensurate with what they would be paying in the private sector for such services, et cetera, et cetera. So getting that in place early may cost some in attorney's fees or professional fees to get that in place, but it will save headaches, litigation, or a penalty period down the road when the parent ends up needing Medicaid. And then a big one that I run into is parents adding their children or family members onto their accounts or onto their property as joint owners. This could be a bank account, this could be the deed to the house. Many times, individuals add their children onto those accounts, either because it makes writing checks for them easier. So if the child is taking a greater role, more active role in paying the bills, paying the monthly expenses for their parents, it's really easy if they're a joint owner on the account. But once it comes time to apply for Medicaid, all of those assets now in that account are going to be counted as a transfer without consideration and could trigger a penalty period, or could just cause problems with valuing what exactly is the amount the parents have for calculating that $2,000 in exempt resources. So combining accounts where both the parents and the children are adding their own funds into the account creates an accounting nightmare when it comes time to try and get onto Medicaid. So if you want assistance from somebody else in paying the bills and managing that day-to-day stuff, don't add the person on as a joint owner. Use a durable power of attorney. They'll have the authority as agent to sign on your behalf without any issues of who owns this, how is it owned, what do we do from here? All right, so for avoiding penalties, some of the stuff that we've talked about, making sure that that contract is in place for caregiving. I can't stress that enough. Oftentimes people don't think about it, and that's perfectly reasonable. Why would you think about that? But it does create problems on the back end. So you're attending this presentation. If that's something that you're looking at, get that contract in place up front so that there's no issues on the back end. If gifting is something that is important to you and you're looking at Medicaid, make the gifts 5 years before getting onto Medicaid, especially if you have sufficient assets to private pay 5 years of care. There are some options that are available for preserving wealth, and that can be even as we get closer into the date that you actually need Medicaid. It does get hard when you're looking at a sudden onset disability where you're perfectly healthy one day and then the next you've got a car accident or something that accelerates the rate at which you're going to need long-term care services, and you still want to preserve assets. It does get more difficult in that case, but there are still some ways that we can do that. And then keeping all documentation. So if you've got a family member, a friend that is buying you things, that is taking care of things for you, and you are reimbursing them, especially if it's large dollar numbers, make sure you keep documentation of what that reimbursement is for, so that when it comes time to apply for Medicaid, that shows up as reimbursement for services, i.e. fair consideration, and not showing up as a gift or a transfer without fair consideration. Same thing if you're acting as agent for a parent or for a loved one. You've already got a fiduciary duty to keep track of everything that you're doing, but make sure that the documentation is precise so that if there's ever a question, instead of getting into a, well, this is what I was doing and it's my word, it's a fairly straightforward handover of documents to the county technician that's processing the Medicaid application saying, this is what I did, this is where all this money went, this was all for mom and dad's benefit, now they need Medicaid, and none of their money was going to me or to siblings as part of a gift or a way to avoid them paying for their needs. Okay, we're on Medicaid now. We've gotten through that eligibility process. What happens next? Long-term care Medicaid steps in. They pay all of the long-term care needs that you have. They pay for nursing facility. They pay for in-home care through maybe a home and community-based services waiver if you don't need to go into a nursing facility. But they keep track of every penny that they spend on it. So it's during your lifetime, while you're eligible, Medicaid pays the bill. After you die, Medicaid has a claim against your probate estate for any money that Medicaid spent on your behalf during your lifetime. And that is called Medicaid estate recovery. Every state has some version of this. It is required under the federal regulations. And essentially, because you've already spent down to under $2,000, there's oftentimes not much of an estate for Medicaid to recover against, with the exception of most people have that house. And that house was exempt while you were alive. Once you die, Medicaid might, if they know that you've got that house, might be saying, all right, we want to get reimbursed from the equity value in that house. And they're actually required to do so under the federal regulations and Colorado's state regulations. In rare instances, Medicaid may place a lien on the house during the individual's lifetime. This doesn't come up very often, but as part of the new Medicaid application process, Medicaid sends a special form to all applicants, whether you're applying for normal Medicaid, that income-based one, or whether you're applying for long-term care-based Medicaid, to disclose any interest you have in real property. So they've learned that they have been leaving a fair amount of money on the table after people die, and they're now building up their database for which Medicaid recipients have houses that we can then maybe go after they die to get reimbursed for some of the money that we're spending on this very expensive program. All right, so jumping back to how do we protect assets for one spouse, because that's oftentimes the best place where we've got some room to protect assets and so that we're not impoverishing the community spouse. We're essentially relying on that difference between how assets are treated and how income is treated. So since assets are all considered jointly for the purpose of the Medicaid application, there's not a whole lot that we can do, by retitling stuff in one spouse's name over the other, but we still want to take care of that piece because of the estate recovery piece. So if we've got a healthy spouse who's going to be in the community, doesn't need Medicaid, and one who needs that assistance with activity, with daily tasks, then we want to retitle everything into the healthy spouse's name so that if the Medicaid applicant spouse dies first, it's all sitting in the community spouse's name, and we bypass estate recovery because there's a specific carve out for assets that are part of the estate that go to the surviving spouse of a Medicaid recipient. And then we also want that because the community spouse can then pass their assets when they die, if they die first, on to whoever they want. Colorado does have elective share requirements, meaning that the spouse of a decedent has a right to some portion of that decedent's estate. It's usually 50%, but we can use that by doing a special means trust for the portion that's going to be for the Medicaid spouse. And what that is a special trust with provisions designed to make sure that those assets are available to the Medicaid recipient spouse, but don't count as an asset for that Medicaid eligible spouse. I won't go into the details of what those requirements are because that's going to take too much time, but that is a planning tool that can be used to preserve those assets in a way that doesn't jeopardize their Medicaid eligibility, doesn't kick them off Medicaid when the healthy spouse dies, and also provides some avenue for at least a portion of those assets to be passed to children or friends or family or charities or whoever the deceased spouse chooses. All right, another planning technique that we look at is if you know someone that you want to take care of after you die, or someone that you care about is a Medicaid recipient, you want to be aware of that $2,000 amount, that limit, and those income limits. Because what we don't want to do as part of an estate plan is give this gift after you die to an individual who's on Medicaid and have that gift cause them to lose their Medicaid benefits. That kind of defeats the purpose. Now we're private paying for something that they were getting good quality care on already for free. And maybe that money could be better used for their benefit through supplemental purchases. So we don't want to make direct benefits, direct bequests, direct gifts to Medicaid recipients. Instead, maybe we make direct gifts to a family member who we trust to use some of that for their benefit. If we want more control than that, then we may want to use a third-party supplemental needs trust or special needs trust. The terminology is able to be interchanged, but it's that trust that I was talking about just a moment ago, where it doesn't count as an asset for the Medicaid recipient, but it is then money that's available for things that Medicaid doesn't cover. Maybe a new laptop so they can be connected to people as technology updates, a more comfortable couch, clothing, things that Medicaid does not cover or covers on a very limited basis. All right, one thing that a lot of clients ask me about is asset protection. And I've touched a little bit on it. It's essentially, some of it is just knowing that this exists so that you're aware. These are the things that we have to be thinking about if we're going to need long-term care. But in any case involving asset protection and Medicaid, we are talking about trade-offs. So the first consideration is if you don't want to have that money be used for your private pay, or you don't want it to go through to Medicaid for estate recovery, we got to be looking at 5 years out for gifting purposes. A lot of people don't want to do that. You're giving up your access to your assets right now to maybe prevent them being used for your long-term care or to reimburse the state at some later date. The biggest trade-off is almost always the trade-off between keeping some asset for a loved one, for a child, for an inheritance, versus your autonomy and control of that asset. Because as long as you have control of that asset, it's going to be counted for Medicaid. So any form of asset protection does mean that we are divesting your ownership and your control of that asset entirely to make it so that it's not able to be glommed onto by Medicaid. Okay, and that's everything I think that we've talked about. Just from, this is a 30,000-foot overview of the long-term care Medicaid program. And I see I've got at least 5 questions or a couple questions. So at this point, I'd like to open it up. If anyone has questions, please take, I'll take the next however long I've got to answer and address those. Thank you.
So John, do you just want to go ahead and look at those questions in the Q&A, or would you like me to read them for you?
Yes, okay. So I'll start with the order in which they are here, and I will read them out so that everybody can hear them in case you're not looking at them yourself. But we've got the first question is excess income held by the nursing home or nursing facility ever accessible by the senior, and under what circumstances? So I think this is in reference to the income trust. But in any event, once you're on Medicaid, once you're on long-term care Medicaid, let me back up because there is the difference, but we're talking about long-term care Medicaid here. Once you're receiving long-term care Medicaid, all of your monthly income goes to pay for your long-term care expenses. You get to keep some portion of that called a personal needs allowance. And that's and I don't know what the exact number is right now. It's in the 90s. So about $95 per month is yours to do with as you please. That's your personal needs allowance. All of the rest of the income that you get every month goes directly to pay for your long-term care needs, either to the nursing facility or to your in-home providers if you're receiving it through a waiver program. So there's a couple of things that we're thinking about with that income. First is we won't need to keep it. You need to spend it, which usually isn't the problem, but you do need to spend it so that you don't go over that $2,000 in countable resources and get kicked off Medicaid for being over-resourced and then have to spend down and get back on. The second thing is if you're in a nursing facility specifically, sometimes that $95 or whatever you're getting isn't enough for the non-Medicaid service that you need. You may have a dental bill that's going to be $3,000. Well, you can't pay for it out of pocket because you can only have $2,000, but $95 a month isn't going to get you there either. And there is a process in place for what are called petty requests. And I'm now forgetting what the acronym for petty stands for, but it's essentially a request made to Medicaid saying, I have this need that's not covered by Medicaid that is going to cost X number of dollars, $1,500, $2,000, whatever. And if Medicaid approves it, then your $95 a month, your personal needs account gets used going forward to pay for that expense that you've now received. So if it costs $3,000 and you're getting $100 a month for the next, as you can see, for the next 30 months, you're going to be paying. You're not going to be receiving your personal needs allowance. That'll be going to paying for that service. So it's pretty limited in what it does cover, but you do get, and I'm forgetting the exact number, I can maybe look it up, but it's about $95 a month to do with as you please. The second question is, if you do have a written contract with a relative, does that change the outcome of funds paid? I'm not sure exactly what the question being asked is, but what it does is it ensures that all of the funds being paid to the relative get treated as payment for services rather than as a transfer without consideration. So you're not running into an issue of a penalty period for the value of those payments made. Other than that, the funds go to the relative to do with as they please. It's essentially, the only difference is you're now talking about a contract between related parties, family members, rather than with a separate entity, a company. Does Medicaid's right to assets after death trump beneficiary designations made? This is an excellent question. So Medicaid is, after you die, Medicaid's right to estate recovery is as a creditor of the estate. They are a priority creditor, which means they take precedence before, say, credit card debt or most other payments that need to be made for debts owed when you die. You can sometimes make direct distributions. So if you've got a beneficiary designation, it doesn't go through your will. It goes to whoever the beneficiary designated is, but it doesn't protect it from creditors of the estate. If it's something that would otherwise be part of your probate estate, those creditors can still go through a process to open up an estate, grab onto those assets, and put a lien on them. So it is something that I talk about with clients on whether it's beneficial to do beneficiary designations or to leave a will. And it often depends on a client by client situation because there are some instances where we can avoid estate recovery anyway through your planning without having to rely on essentially keeping these assets hidden. One thing that I haven't seen a lot of from Medicaid is, and I think this will change now that they're starting to get information on which of their recipients have houses, because I think they noticed we're not recovering a very high rate. So they started doing that about 15 months ago prior to getting that information from clients, Medicaid was really bad about following up after individuals had died to file their claim, unless someone opened up a probate estate for the Medicaid recipient. So a common thing that people would do is they would sit and not open up a probate estate, leave the house vacant, continue to pay the mortgage maybe, but essentially not touch it. Wait 1 year after death and then open up the estate. After 1 year, all creditor claims are barred, and that includes Medicaid claims. So the strategy was kind of, okay, we understand we have to pay this estate recovery, but the burden is not on us to pay Medicaid. The burden is on Medicaid to make that claim. We'll just wait and see. And if they make the claim, great, we'll pay it. But if they don't make the claim, we'll treat them the same as any other creditor. I think that with this new information, that strategy will no longer work, that Medicaid will be more proactive in seeking estate recovery for estates that have not been opened by family members. They'll use their rights as a creditor to open the estate, place the lien on the house, and get paid. So I think that's a kind of off target for the beneficiary designations, but one of the reasons that beneficiary designations kind of worked in the past was because we could avoid the necessity of opening up probate altogether, and Medicaid would just fail to make their claim. If everything passes by beneficiary designation, but Medicaid makes the claim, they can still come back and get those assets. What prevents Medicaid from going after assets upon death? There's the one thing that I just mentioned, which is just lack of coordination between the Medicaid departments, not following up, not understanding which of their recipients have houses, have assets to go after, and just leaving assets on the table that they have a legal right and arguably a legal obligation to go get. The other primary things that make Medicaid not seek assets after death are if one of the many exemptions to estate recovery is present. The primary one being if a spouse of the Medicaid recipient is the one receiving the assets, Medicaid estate recovery does not apply. Those assets go to the spouse, no questions asked, no fight. Another common one, somewhat less common, but still common, is if the recipient of the assets after death is either a disabled individual, so someone who may be eligible or at least medically eligible for long-term care Medicaid themselves, and that by receiving this asset, they don't need Medicaid, then Medicaid won't touch it. Or for a child caregiver who was providing in-home services to the Medicaid recipient for at least 2 years, and that by providing those services, the Medicaid recipient was able to avoid going on to Medicaid for those 2 years. If those situations are present, then estate recovery does not apply. They can't go after the assets. Another situation that's kind of on this, but not exactly, there's a slight variation, is those long-term care riders under insurance policies. Oftentimes, they will have a Medicaid compliant provision, which means that whatever the long-term care insurance company pays, the individual gets to keep that much more in assets and become eligible for Medicaid. So you can get onto Medicaid with more assets still in your name that can then be passed along to family members. Plus you're getting a private company to pay for a number of months or years of your care, meaning Medicaid's not paying as much and your estate recovery amount is going to be lower by the time it actually gets to that. And then the last question that I'm seeing right here is, how do reverse mortgages affect collecting Medicaid or recovery by Medicaid? And that's a good question. Reverse mortgages do play in some to Medicaid discussions. Oftentimes we use them to delay the moment that we have to get onto Medicaid. So using the equity in the house to create a revenue stream to cover needs if we need to make it to that 5-year look back period, or just to cover things that Medicaid does not cover. The way Medicaid treats reverse mortgages is that any money taken from the reverse mortgage counts as income in the month it was taken. So it doesn't affect your assets at all, but it does affect your income. And so making sure that we keep it within that range that doesn't disqualify you from eligibility for Medicaid, whatever the regional amount that's permissible is, using an income trust. Gets a little bit tricky there because if we've got that, all of that income needs to be going to pay Medicaid anyway. So once you're on Medicaid, reverse mortgages lose some of their utility, but they do count as income. One of the things about reverse mortgages, obviously, is once you die, it either has to be paid right away or the bank can foreclose on the property, or the mortgage holder can foreclose. In that case, oftentimes Medicaid's going to get their piece of the pie. You die, the bank starts the foreclosure process, Medicaid files their claim for assistance, and it's going to be an issue of competing creditors. The bank is going to have priority. They're the ones who are the secured creditor in this case. But whatever's left after their claim is made, Medicaid's probably going to take and grab onto. If there's anything left at that point, it can go to beneficiaries under an estate plan. Oftentimes, if we're using a reverse mortgage aggressively, there's not much left by the time that we get to that point, but that's a piece there. Is there any other questions?
I don't see any more coming in right now, John. I'm back. Hi. So yes, if we don't have any more questions, I'd really like to thank you, John, for that presentation. It was just chock full of really helpful information. So thank you for doing that for us. And I'd also like to once again thank our sponsors, the Boulder County Bar Association. Let me pull up this screen so I don't miss anybody. Pro Fiduciary Services, Frazier, Jorgensen, Brownell and Pepin, Huff Garden Associates, BOK Financial, Kingsbury, Johnson and Love, and Friends of Longmont Senior Services. So thank you everyone for participating today. You can always send questions afterwards to info@bocoseniorlawday.org. John, I didn't see any contact information for you, but if there are more questions, shall I just forward them on to you?
Absolutely, and I can give that to everyone now.
Great. Why don't you do that? I will stop sharing, and if you have that written down somewhere. Let's see. Put it in the chat box there. Okay, we want to make sure it gets out to everyone.
And all right, so my that should be 303 for the phone number.
Okay. And I'm just going to, right now, that's just going to the hosts and panelists.
Okay.
I don't know if you can quickly change that over to everyone, but I could copy and paste that and get that off as well.
Let me change that to everyone real quick.
Okay. Yeah, we want to make sure people can contact you if they have further questions or need your services. Excellent.
Excellent.
Go. All right.
All right. Well, thank you. Thank you all for joining me this afternoon, and have a wonderful afternoon.
Okay. Thank you. Well, all right.